they seem to be all right now. Well, good morning, everybody. Welcome again to day 2 of the hearing for the Waikaka Gold Mine application for resource consents. Before we introduce ourselves as a panel, we'll just start with a karakia.
Kia ora koutou. Kia ora koutou. The karakia for this morning is going to be whakataka te hau, which talks about winds calming, and this is often used as an analogy for careful and considered decision making. So I think it's rather appropriate for this morning. So, mea noi tātou. Whakataka te hau ki te uru, whakataka te hau ki te taonga, ki a mā kina ki uta, ki a mā taratara ki tai, e hi ake ana te atukura, he tio, he huka, he hauhu, ti hei mauri ora.
Thank you. And because we have some new people in the room and I'm online, we'll just introduce the panel again. So my name's Ian Boothroyd. I'm an accredited independent commissioner with the chair endorsement.
Morena koutou, my name is Ros Day Cleven. I'm an independent commissioner based in Otapoti, Dunedin.
Kia ora anō tātou, ko Stephanie Dykstra tōku ingoa, ko kaitahu me te kati māmoi o ku iwi, ko oraka aparima me awarua tōku runaka, no o tautahi ahau. So my name's Stephanie Dykstra. I'm also an accredited independent hearing commissioner based in Christchurch. I have whakapapa links to awarua and oraka aparima, but I am not a member of Hokanui Runaka.
Thank you. Now we'll just get Ms. Ongo just to run through the health and safety procedures once again.
Kia ora, my name is Catherine and I'm the consent coordinator at Environment Southland coordinating the hearing today. The health and safety at Border Street Council Chamber is just in case of fire emergency, please follow council staff out that door behind you and to the right, then turn left to exit the main building, and the assembly point will be to your right. For the toilet, it will be out that door again, turn to the right, and then turn to the right again. And you'll see the signs. Thank you.
Thank you. And I just remind everyone to turn their mobile phones off, please, for all the proceedings. We've got a timetable for the day, and I believe, Mr. Pemberton, you're online. Can you hear us okay? Mr. Pemberton, are you in your room? We can't. Your microphone is muted, and we can't hear you. Maybe we can just follow up on that a little bit. Maybe he's not in the room after all. Thank you. Thank you. My purpose in talking to Mr. Pemberton is that we do have some applicant matters just to deal with and some admin matters at the beginning, so we can probably head into that whilst... so we'll just deal with that right now, and then we'll come to you and your presentation and your submissions.
Okay, thank you very much.
Thank you. So, I'll just clarifying whether you can see the panel front on now.
That's much better, thank you.
Thank you. Okay. So we'll come back to you very shortly for your submissions. Thank you. So, Ms. Colley, I'm sorry about all these disruptions.
Oh, no, that's fine. We were talking about cultural monitoring, and I mentioned that it's provided for in the strategic relationship agreement between Waikaka Gold Mines and Hokanui Runanga. We have a baseline of cultural monitoring available to us, and that Hokanui Runanga have not asked us specifically to include any conditions requiring cultural monitoring.
Any further matters? Okay. I'd just like to raise one, and we talked yesterday about receiving the amended consent conditions next week. I wonder, associated with that, can we also receive a list of all the management plans that are required coming out of those conditions and which condition they refer to, and any linkages that might occur between them, and perhaps some thought as to whether any of them can be perhaps either amalgamated or shortened together, something like that. That would be helpful just to have that in front of us at the same time.
Yes, certainly.
Thank you.
Yeah.
Thank you. And that would be to that same time frame. Yeah. Thank you. All good? All right. Happy with that? Thank you. Thank you, Ms. Davidson. So, Mr. Pemberton, if you come back online now, we are in your hands for your submission.
Thank you. Tēnā koutou katoa. No whaktua hau ki whaktua hau I noho ana. He roe te tau taku mahi. Ki te papa te whae hau I mahi ana. Ko Matt Pemberton tuku ingoa no reira tēnā koutou, tēnā tātou katoa. So, yes, I'm Matt Pemberton, Counsel for the Director General. Sorry I can't be with you in person, and thanks very much for accommodating me remotely from Whakatū, Nelson. I understand the panel has a copy of my written submissions, is that correct?
That is correct, thank you.
Great. If there's any way the camera can be changed so it's not on the back of your head, I don't know, I can probably try change my view, that would be better, but yeah, I don't know if that's possible. It's just a bit easier to see who's asking questions, etc. Yeah, that's it there. We'll see, yeah, if it can stay on that view, that'll be great. So what I understand the panel has a copy of my written submissions. Catherine's kindly printed them out, is that correct?
Yes, we do have a copy of the legal submissions in writing. Thank you.
Thank you. I plan on walking you through these, and then I was planning on calling two witnesses, two Janes, but you've heard from one of the Janes, Miss Bowen, yesterday, so I'll just be calling Ms McLeod after that. So I will move straight to paragraph 4 of my. So I'm just presuming you haven't had a chance to read them, so I'll just step you through them. Would that assist the panel?
That will assist us greatly, thank you. You're correct, we haven't had time.
Moving on to the legal framework for considering the application, I won't run you through section 104.1 because I'm sure you're familiar with that, but I just set out there in paragraph 15 the key statutory framework, including in relation to the consent application with Environment South and the relevant provisions of the higher order and lower order planning instruments that you have to have regard to. And moving on to paragraph 16, in considering the adverse effects of the proposal, you may disregard an adverse effect of the proposal if the plan permits an activity with that effect. That's a discretionary power referred to as the permitted baseline. And I agree with Ms Smith that the permitted baseline is not relevant to this application. And as noted above, you may decline the application if you consider you have inadequate information to determine it. And as Ms Davidson's already highlighted yesterday, as the application's a non-compliant activity, you need to be satisfied that it is able to pass through one of the gateways in section 104D before you're able to consider whether to grant consent in accordance with section 104. So now turning to the gateway test as it's known in section 104D. So I've set out that provision in para 19, and moving on to para 20, you must be satisfied that the proposal will cause no more than minor adverse effects, or that the proposal is not contrary to the policies and objectives of the proposed Southland Water and Land Plan. So just moving through those two discrete pathways that the application has to fit into, in the first instance, the minor aspect, which is the first gateway test requires effects of the activity to be no more than minor. And while the term minor is not defined in the RMA, the Environment Court has confirmed it to mean lesser opposite to major, comparatively small or unimportant, and that what is minor depends on the context. And the High Court has explained that the gateway test in section 104D1A is akin to passing through the very small eye of the needle, i.e. the appropriate standard is that the adverse effects are so minor that they are not likely to matter in any decision to grant consent. Then moving on to contrary to, the meaning of contrary has been held to be opposed in nature, different to or opposite, repugnant and antagonistic. In Queenstown Central case, the High Court took a divergent approach, finding that where a proposal was contrary to a single objective in the relevant plan, that was sufficient for the proposal to have failed the second limb of the gateway test. My submission that as the law stands, the panel does need to consider the objectives and policies as a whole, and this requires planning provisions to be considered comprehensively and where appropriately reconciled. Not contrary to sets a high test, and if the application is contrary to a policy, which is, when the plan is read as a whole, very important and essential to the proposal before the consent authority, it is open to, in my submission, it's open to the consent authority to find the proposal is contrary to the objectives and policies under section 104D. And I just note in relation to the application of Environment Southland, the relevant plan is the proposed Southland Land and Water Plan. And in my submission, the application does not pass the first gateway, as the proposal would have more than minor adverse effects on the environment. And the evidence is that the application will have more than minor adverse effects on freshwater ecology and is contrary to the relevant objectives and policies of the proposed Southland Water and Land Plan, including policy 28A and 32. So now moving on to legal context. So I've just set out on top of page 7, of course, if you determine the activity passes through the section 104D gateway, then you obviously have 2.4 as an environmental bottom line, the application must meet to be granted consent. So the Supreme Court in King Salmon held that avoid means not allow or prevent the occurrence of. And as the planning evidence has noted, policy 28A of the PSWLP was added to give effect to this clause, so it mirrors it. And the loss of river extent or values must be avoided unless there is a functional need for the activity in that location, in which case the effects are able to be managed by applying the effects management hierarchy. And I just note another point there in paragraph 45 about the strength of directive policies, and the court in King Salmon was referring to the NZCPS, which had very directive avoid policies 11, 13 and 15 relating to biodiversity, natural character and landscape. And the court in that decision said lower policy in NZCPS cannot be a rule within the special definition in the RMA. It may nevertheless have the effect of what in ordinary speech would be a rule. So obviously there's been developments in case law since King Salmon, and Ms Davidson walked you through those yesterday, so I'll just touch on them briefly. But I know you're particularly interested in the concept of material harm, so I've addressed that at para 46. And so that arose, as Ms Davidson pointed out, from a Port Otago Supreme Court case, and it essentially incorporated the reasoning from the Trans-Tasman Resources case, which was under a different statutory framework, the EEZ Act, which first coined the term material harm. And the Supreme Court in Port Otago referred to its decision in King Salmon, referring to its decision in King Salmon, I think this is important. The Supreme Court held that NZCPS avoid adverse effects policies must be interpreted in light of what is sought to be protected, including the relevant values and areas, and when considering any development where the measures can be put in place to avoid material harm to those values and areas. So, and there's been another Supreme Court case, of course, since Port Otago, which is East-West Link, and in that case, the Supreme Court that avoid policies may be met with offsetting. However, the court also confirmed that offsetting requires like-for-like measures and avoid policies cannot be met with like-for-unlike measures. And I set out the relevant paragraphs below in para 48. The relevant question is not how to define offset or what kinds of offsets can satisfy avoid policies. It is whether the relevant adverse effect can be avoided. In fact, if the contention and the evidence is that adverse effects at the level identified in the relevant policy can be avoided through offsets elsewhere, that will be a matter to be assessed by the fact finder. So now just turning to the functional need test, which I've set out. The need for a proposal or ability to traverse, locate, operate in a particular environment because the activity can only occur in that environment. So that this is going to, of course, clause 3.24, and whether it's an absolute avoid or you can go to the effects management hierarchy. The planning consensus is, or appears to be, that's my understanding, that overall there is a functional need for the activity gold mining because the gold resource is at the subject location. And I just want to note, and on a strict reading of the functional need definition, I question whether the activity of gold mining can only occur compensation, including how they comply with the relevant principles in the NPSFM, consistency with policy 28A, which mirrors clause 23.24 of the NPS, sorry, that's typo, NPSFM is not achieved, which is grounds for the application to be declined. So just moving on to fish passage, that's 3.26 of the NPSFM. And I just note there appears to be some uncertainty whether a bridge or ford will be used for stream crossings. And having heard Mr. Batt yesterday and read his supplementary evidence, he said that the company currently favours a bridge design for stream crossings. Regardless, the stream crossing can be designed and constructed in compliance with permitted activity rules and regional plans and the NES freshwater. So I just note there, my understanding is that a bridge or ford can be permitted if all relevant standards under the NES freshwater and regional plans are complied with. But what I don't understand is why the type of stream crossing, i.e. what the in-stream structure is, which is what is specifically referred to in the NPSFM, hasn't yet been specified as part of the application. And I just note that relevantly, clause 3.26 states that the NPSFM provides the passage of fish is maintained or improved by in-stream structures. And in my submission, the application should have clearly stated whether crossings will be bridges or fords, included design drawings and explain compliance with the NES freshwater and regional plan standards. Because in my submission, even if whatever structure was chosen was permitted, then the consideration of effects would fall under the permitted baseline, which is discretionary in any event. So I just think as part of complete application, it should have the in-stream structures should have been specified. For example, if it was a ford, then there could be sediment issues with the level of trucks and vehicles crossing it, etc., which could be considered. So just some brief comments on the officer's report, para 65. Director General supports the Ms. Smith's report, in particular in regard to the section 104.1a adverse effects being more than minor, and in regards to section 104b, 1b, the activity is inconsistent with strong directive policies of the relevant planning documents. And thirdly, following the effects management hierarchy, more than minor residual effects have not been avoided, minimised or remedied, and this includes the loss of river extent and habitat values during diversion. Further, temporary adverse effects of loss of river extent, habitat values, indigenous biodiversity, taonga species, river and ecosystem values, and cultural values are not proposed to be avoided, remedied, or mitigated. Ms. Smith considers that the decision to grant or decline consent is finely balanced, as this can be contrasted with the Director General's view, which is in the absence of further information being provided by the applicant, that the application should be declined. So just briefly touching on Ms Bowen's evidence. In summary, she does not support the proposal to divert Shepherd's Creek and Waikaka stream due to the effects on habitats and freshwater species. She has concerns about the proposed reconstruction of the Waikaka stream and Shepherd's Creek. She does not believe that the rehabilitation has been appropriately scoped or managed, and is concerned that reconstruction may not be successful due to the scale and complexity of this work, and information is lacking to assess the adequacy of the proposed reconstruction. Thirdly, she does not support the realignment and infilling of drains as detailed in the proposed context, given the habitat and legal submissions, which I just haven't, in the time available, been able to put into writing. So I'm happy to pause and ask for questions and have questions, or if time permits, quickly address those comments, but I'm in your hands.
I think Mr Pemberton will hear those points and then we'll consider some questions.
Okay, thank you. So just turning to paragraph 22C of Ms Davidson's legal submissions, she states that there is no evidence that the proposed rehabilitation is impossible. So this is what I understand she's talking about there, is the rehabilitation of the Waikaka stream, which could be achieved within a reasonable time frame, which I understand to be 5 years, according to the applicant. And I just note that the onus isn't on submitters like DOC to prove that rehabilitation is impossible. It's on the applicant to prove that rehabilitation, in terms of the Port Otago speak, avoids material harm to loss of river and extent and values. So my second point to make is in relation to paragraph 24 of her submissions, where she says that it's not the case that mitigation is highly speculative, or where there is a reasonable expectation that despite conditions of rehabilitation might completely fail, and Mr Dungy remains confident that rehabilitation will be effectively fully achieved within 5 years, and in worst case scenario it might take slightly longer. And I just know that I don't
Mr Pemberton, sorry, Mr Pemberton, pause. Can I just pause you a minute? We lost you very briefly there in the last 2 minutes. Okay. Sorry, so perhaps you can repeat the second part of your comment too.
The second point. Okay, sorry about that. So I'm just referring to paragraph 24 of Ms Davidson's submission. Would you like me to read it out, or have you got it in front of you?
We have it in front of us, thank you. No need to read it out.
Yeah, okay. So I just make the note that in relation to rehabilitation,
Mr Pemberton, I'm sorry, Mr Pemberton, I might just pause you again. I'm sorry you dropped out again at that last sentence. It doesn't seem to like paragraph 24 very much.
Sorry, my feed's suddenly getting a bit patchy as well. Can people online just confirm if they can hear me? Jane Bowen, are you online? Just so we can try to work out what ends the issue's at, because it might be from your end in Gore, I think, because the feed just seems to be a bit patchy. Can anyone else online see and hear me okay? Just so we can work this out.
I can hear you okay, Matt. Sorry.
Yeah, and my visuals are okay.
I think Mr Pemberton, I might just pause you again there a minute, rather than directing. Everyone can hear. I mean, I'm quite comfortable if you want to turn off your video, that might aid things, and then turn it on again for our questioning. But while you go through these points, perhaps turn it off. That may help.
All right. Can you hear me? Can you hear me okay? now?
We can hear you okay, yes, thank you.
All right, thanks. Well, just third time lucky, I guess, with making this call. Are you able to perhaps turn both your cameras back on? For if you've got any questions, that would be helpful, I think, to be able to see who's asking them from my perspective.
We should be back on camera.
Yeah. One of the cameras is on, but not the one where I could actually see you all properly.
Whilst that's being worked on, Mr. Pemberton,
Yeah.
are we able to receive those 6 points you've made in writing?
Yeah, sure. I can. Yes, I can do that and provide them to you by close of play tomorrow. Would that be suitable?
I think I will. I will accept that. Thank you.
Okay.
Yes.
Yeah. Okay, I'll do that.
So I'm just making my own notes on that.
Thank you, Mr. Pemberton. I have a couple of questions for you. Can you hear me okay?
Yeah, can hear you fine. Thank you.
Thank you. So I'm interested in... Sorry,
I lost you.
That's okay. My microphone cut out, so I'm back on now. Here.
Okay. Great.
So an issue traversed. Okay.
I'm still having trouble hearing you.
Mr. Pemberton, yeah, we're having some trouble with the microphones ourselves here, so please bear with us. There we go, look.
Take that one.
Oh, gosh. What a pain. Mr. Pemberton, I'm now back with a working microphone.
Yeah. Okay, great.
So, a key issue that was traversed yesterday in legal submissions and also planning evidence was this distinction between residual effect and temporary effect. You've touched on this today, but I just want to make sure I've understood your position. Can you talk me through, from a legal perspective, so putting aside the planning and the ecology evidence, I'm just wanting to hear from you on the distinction between a temporary effect and a residual effect as it stands in law?
Sure. Yep. So key thing, I think, is that there shouldn't really... a temporary effect isn't an effect. That's the key thing. So I touched on that. Section 3 of the RMA defines effect to include temporary effect, and that includes regardless of its duration. So the key thing is it's having an effect. It doesn't matter if it's a temporary effect. And I guess that's the legal point, is temporary effects still need to go through. If you conclude, I mean, that's open to you as a panel to conclude that this is a temporary effect, and looking specifically at the loss of river extent and values through the, clear evidence before you about the length of time that that's going to occur. So I suppose, that's the second aspect of it.
Thank you. And I had a question for you in your delivery of submissions this morning. You mentioned that we should take caution in relation to a particular case. I'll just try and find this. and I wasn't clear what. Just
sorry,
if you just let me finish, please. Just.
Sorry.
Because I just want to find my notes so that we can be sure I'm asking the question I want to ask. It was a case where you said that we should take caution given the temporary effects or the context was different, but I'm unclear what you were meaning there.
I think I know. Yep, sure. I think I know. That was the fifth point I was referring to in Ms. Davidson's submission.
Yes.
Submissions, and that was at paragraph 45. And look, Ms. Davidson acknowledges actually in paragraph 45, while that decision concerned a different statutory context. So it is the Trans-Tasman Resources case, and that was a case that was made under the EEZ Act, so a different statutory context, because the proposal was outside of RMA's jurisdiction. So she's highlighted the passage there in relation to temporary in relation to temporary adverse effects do not necessarily mean material harm will be in contravention of an avoid policy. And I was just noting that it was in a different statutory context.
Thank you.
Does that make sense? Does that answer your question?
Yes. So it's a different statutory context, but what specifically should we be taking caution with? So the principles still apply in this case? Or?
Well, I don't think it's directly applicable. That's in the sense that I agree that the context of material harm was brought in through Port Otago, but I just don't. My understanding is what she's saying there in relation to remediation of temporary adverse effects. She's not citing a direct case from the RMA, so I'm just saying that reference should be treated with caution because it's not exactly the same statutory context. I appreciate though that the definition of effect is the same, but it's not made under the same same decision-making criteria. That's all. That's a point I can hopefully articulate a little bit better when I put those thoughts into writing as the chair's requested.
Thank you. I think that would be useful to understand your concern there. Thank you.
Thank you, Mr. Pemberton, for your submission. I had two questions. The first was regarding point 13A and 13A in your legal submission. And I just wanted to query if our proposal to the ecologists yesterday requiring them to come back with.
So just putting values aside and thinking of extent, the extent is that a temporary extent in your mind, or is that fully complying and not avoiding extent of the watercourse?
Yeah, that's a really good question, isn't it? Because I see, look, I think extent is talking about, that's a good question. I mean, I would think extent is talking about the extent of the river that's actually there in its natural flowing form as opposed to a diversion. That's my, I suppose gut reaction to it, but I don't think loss of it's like loss of values is specifically defined, but it's a good question, but I could see how arguments could be made the other way in terms of, extent hasn't been lost because we're creating a diversion at all times. So, collectively the river's still able to flow. But I suppose without having given this a huge amount of thought, my gut reaction is it's actually talking about the river in its natural flowing form as opposed to a man-made diversion, which creates, a channel. Yeah.
Okay, thank you. And you're not aware of any kind of legal case or opinion on that matter?
No, I'm not off the top of my head, sorry.
Thank you. And I think the question previously about the lag time, that is more about the values as you responded. Is that correct?
Yes. Yeah.
Okay.
Yeah, that's correct. Yep.
Thank you, Mr. Pemberton. I don't have any further questions now. So thank you for joining us online. Are you staying online with us for the remainder of the day?
Yeah, at least for this morning. And would you, I'm in your hands, would you like me to call Ms. McLeod, or would you rather she just introduced herself in person? I'm happy to do that formally if
well, we're going to take a short break. We're going to take a short break now before Ms. McLeod. So maybe Ms. McLeod, you introduce yourself if that's happy. Either way. I know I asked the applicant's lawyer to introduce her experts, but given the nature of the online, I'm happy with that. So we're going to take a short break. So thank you, Mr. Pemberton. Thank you. And just a reminder to provide those 6 commentary points, which you said you do by the close of business tomorrow.
Sure. Thank you very much for your time.
I'm sorry, perhaps you can articulate that. My fellow commissioner has a further point.
Yeah, just given that last question around extent, if you are able to provide further thinking and potentially some case law around that, that would be quite useful.
Yep. Yeah, happy to do that. Thank you.
Thank you. Actually, I'm going to change my mind. Actually, just on that, I'm going to ask you to introduce Ms. McLeod. I feel like I need to be consistent with this, so please do that. But right now, we're going to take a short break. If we can be back at 10:40, is that acceptable to everybody? Thank you very much. I was going to ask actually about everyone's level of comfort with the temperature. Are we all okay? No particular?
I'm from here, don't.
I think we're good.
Where's the last person you asked if it's too cold in the room?
Okay, thank you. We'll reconvene. And Mr. Pemberton, if you'd just like to introduce your witness.
Thank you, sir. Can you confirm your full name is Jane Elliott McLeod and you have the qualifications set out in your evidence dated 25 November 2025?
Yes, that's right.
And you've prepared a statement of evidence and a summary statement dated 4 December 2025?
Yes, that's right.
And you participated in an internet conferencing and produced a joint witness statement dated 2 December 2025?
Yes, that's correct.
Are there any corrections you'd like to make to your evidence?
Yeah, there are a couple of corrections. I'll just address those in my summary, if that's okay.
Okay, thank you. And your evidence is otherwise true and correct to the best of your knowledge?
Yes, that's right.
All right, thank you, Ms. McLeod. I'll leave you in the panel's hands.
Thank you. When you're ready, Ms. McLeod.
Thank you. I provided planning evidence in relation to the Director General of Conservation's submission on the proposal by Waikaka Gold Mines to establish and operate a gold mining and processing operation. DOC's submission related only to the application to Environment Southland, and my evidence therefore focuses on the effects of the activity covered by that application rather than the application to Gore District Council. Effects of concern to the Director General arise from the temporary diversion of the Waikaka stream in Shepherd's Creek and from the disturbance of drainage ditches and ponds elsewhere on the site. I consider that it includes a clause that specifically refers to threatened but not to at-risk species. The policy reads, manage a full range of Indigenous habitats and ecosystems to achieve a healthy, functioning state and to ensure viable and diverse populations of native species are maintained, while making appropriate provisions for lawful maintenance and operation of existing activities. In giving effect to this policy, regard will be had to the following potential adverse effects. 1. Fragmentation of or reduction in the extent of Indigenous vegetation or habitats of Indigenous fauna. 2. Fragmentation or disruption of connections and linkages between ecosystems or habitats of Indigenous fauna. 3. Loss of or damage to buffering of ecosystems or habitats of Indigenous fauna. And 4, loss or reduction of rare or threatened Indigenous species populations or habitats. So I had noted in my evidence that clause 4 was relevant because the activity would result in the loss of habitat of a threatened species. The term rare or threatened Indigenous species isn't defined in the RPS, so the intended relationship between that term and the threat classifications in the NZTCS isn't completely clear. But I think it is reasonable to assume that the term relates to species classified as threatened, but not those classified as at risk. Therefore, given the change in classification for golems, I consider that clause 4 of the policy no longer applies to the activity. However, that doesn't change my overall assessment of the activity against the policy because clauses 1 to 3 do still apply, and having regard to those, I still consider the activity not to be consistent with that policy. Overall, therefore, I consider that key statutory policies are not met. Given that these policies include policies in the SWLP, which is one of the relevant plans under RMA Section 104D, I don't believe that either limb of Section 104D is met. However, I consider that there is potential for effects to be appropriately managed and for the activity not to be contrary to key policies if the following additional actions are undertaken by the applicant. Firstly, in order to have a full picture of the ecological values that will be affected, the ecologist evidence has indicated that further information is needed on the ecological values of Shepherd's Creek and how the ditches and ponds currently connect to each other and to the natural water bodies on the site, and how Indigenous species, particularly golems and longfin eel, use this interconnected habitat. Secondly, a draft stream diversion management plan should be provided with sufficient detail to demonstrate that successful diversion and rehabilitation is feasible. Finally, to appropriately manage effects in accordance with relevant policies,
It should be demonstrated that suitable alternative habitat is available for the translocation of golems and other fish species living in artificial water bodies that will be disturbed, and appropriate measures should be proposed for offsetting and compensation to manage residual adverse effects on river values. My evidence also proposes a range of amendments to conditions to better manage effects if the panel is minded to grant consent, and I appreciate the opportunity to continue to work on those conditions next week with the other planners. Thanks.
Thank you. Ms McLeod, I'll just turn to my
Thank you, Ms McLeod. I had a question kind of aligning with some of the previous ones around residual effects and whether offsetting is or compensation is required. And I just wanted to get your view on whether there will be residual effects that would require offsetting or compensation.
Yeah, my view is that there will be residual effects, even in the case that the rehabilitation is successful. Just looking at the proposal, it's to completely remove the bed of the river and divert it for...
Or have you experienced where it's been applied, where any loss has been returned?
To be honest, I haven't had experience with previous consents that have engaged this policy, but I just feel like on a plain reading of the policy, there doesn't seem to be any indication that residual effects should exclude temporary effects.
So it goes beyond simply just losing or loss. For example, loss of some vegetation which is not being replaced at the location. That's just an example, of course, as opposed to a temporary where it would be replanted at the same location. And that's the same with the stream.
Could you rephrase the question, sorry?
What I'm trying to get at is residual in your mind, in your view and interpretation of the effects management hierarchy something that when we talk about what you're saying can be temporary, that its replacement is still a residual effect. The loss of it and its replacement of it is still a residual impact.
Yes. I think even if values are replaced over time, I think there's still a residual effect from the gap in which they were lost. Okay. And also just noting that there is quite a bit of uncertainty over the extent to which they can be fully replaced.
Thank you. And I think you responded to a question before, but we sometimes or have referred to that as a lag time between the loss and then the return or the gain for that. In this case, a temporary sense, or in other circumstances, it might be in a more permanent sense. So I guess what I'm trying to get at, when you're saying temporary, are you meaning that lag time?
Yes.
Yes. The lag for the values to return.
And just a concern that could be either the 4 to 7 years proposed, or it could be a lot longer.
Sure. Okay. Yeah. Thank you. That just responds to that. And then I think in paragraph, I think it's 74 of your evidence, not your summary, you make reference to offsets and compensation. And we talk here about the policy does not require these effects be avoided.
Yeah.
The healthy functioning state is achieved in a full range of habitats and ecosystems. Thank you. What I'm interested in is a question of if offsetting or compensating measures were undertaken to create positive effects. And what I'm trying to understand, do you mean there that with a rehabilitation, there is more to be done in that compensation space, or would satisfy you that this compensation has occurred?
I think this policy is particularly relevant to the habitat in the ditches and drains. So I think maybe before we get to what the necessary measures are to address that, there needs to be that information gap filled about the values in the drains and ponds and how they interconnect and what species are actually there. Because I did notice that there had been some recent discovery of golems next to Pond 6, where previous surveys hadn't discovered any. And so that seems to indicate that there might be potential for more work to be done. And Ms. Bowen suggested eDNA methods to see exactly what the values are. And then I think after that had been established, it could then be worked out what the appropriate measures to address it were.
Yes, I understand that, but I'm trying to get at there are some measures to provide for it. But what I understand from your evidence is that adding some positive effects or some positivity to that or additional would, a slight adjustment to the room temperature, I think. Is it going up?
Where I turn it up and all of a sudden we're now too hot.
Okay, Ms. Smith, we're in your hands. Miss Catherine, we've got a little bit of problem with the mic again. Thank you. Oh no, we might be fixed. Thank you.
Did you have our summary statements as well? Oh, okay. And I've got this for you.
No. Okay. Did they? Yeah. Okay. So, sorry, you have a copy of our statements. Perfect.
Yes, we do.
Okay. I spent a bit of time thinking last night on what I heard yesterday, and I wrote some notes, and hopefully some of those are helpful.
Ms. Smith, I can move the microphone a little bit closer to yourself. Thank you. Yes.
Okay. I wrote some notes last night, having a think about everything that's happened since the 42A report, all the evidence and all the statements received yesterday, and hopefully some of these points are helpful. I wanted to address Crack Willow because I spent a lot of time last week thinking about Crack Willow, although I think we have covered that somewhat. Just wanted to reiterate that the catchment management team doesn't want to use Crack Willow. They're actively trying to get rid of it. Although, as Mr. Strong mentioned, they don't always want to pull it out because that can leave broken bits behind. So sometimes the management is trimming, and they are using shrub willow as a preference. And yeah, as Mr. Gardine mentioned, the council contractor did some of that trimming this year above and below the mine site, because it was the understanding of the catchment team members who came with me on the site visit that the mine would be removing, and therefore ratepayer money wouldn't need to be spent on that reach. And yeah, everything else is consistent with Mr. Strong's comments. Reasonable mixing zone was brought up yesterday. There is a definition in the water and land plan. And yeah, I believe that's what is proposed is consistent for the downstream. I do think that it is worth considering a monitoring in the surface water monitoring site above and below the entire mine footprint if you wanted to catch all effects. It's potentially not just the direct discharge that could potentially be affecting the surface water quality. And so above and beyond the mine footprint may be worth considering. There is uncertainty about freshwater ecology effects, which we've covered. I think there's also a bit of uncertainty about groundwater and hydrogeology, which Mr. Heller and the joint witness statement and Ms. Badenhop are able to address. And then
it felt like an invitation to spend a bit of time thinking on policy, so I did a bit of that. Not sure. I think there's two options.
We might come back to that. Continue for now. Yeah.
And policy 32 was raised. So the second part of that policy, maintaining Indigenous biodiversity associated with rivers and their margins, is required. Maintain is continue to have, keep an existing state. The interim measures prior to the rehabilitation of the ecosystem being successful might achieve some of this, provided there's understanding of the current state, the current biodiversity, fish salvage and relocation, ability to achieve that, and the habitat features in the diversion channel and in the final channel, some more clarity on those. And I do consider that it could be consistent or not contrary with this policy with those things, including that detailed table of contents for rehabilitation and fish management with monitoring, trigger action, adaptive management type conditions. And then the final section is a bit of a summary of that. I do still think that the decision of whether to grant is finely balanced. Some more certainty of residual adverse effects to be able to apply to the effects management hierarchy. A quantum or scale would be beneficial.
Complete. Thank you. We'll just deal with any questions, perhaps. First.
Thank you very much for having a written reply report, if you like. It's very useful at this point in the hearing to have your responses to what you've heard throughout the process. So thank you, I appreciate it. In terms of your conclusion, the refinements through planner conferencing, are you saying that those refinements could provide the certainty you need to understand the level of residual adverse effects?
Yes, I think detailed table of contents for the various management plans could be quite helpful. And more time spent on conditions, making sure it's clear what is being monitored and why and what appropriate triggers and responses might be. Then I think it could be achieved.
Thank you. And so until you see that or participate in that process, you're, in terms of policy bio 0.9, which states significant residual adverse effects, you'll be then you'll have a bit more comfort at that point how to apply that policy. Is that what I'm hearing? Or?
Yeah, some more comfort would be nice. Yeah, significant adverse effects, residual adverse effects is
Against the effects management hierarchy, make that comment in your summary statement. Just to be clear on what you consider as the whole project. Is that from the very start to the completion of the rehabilitation, hopefully a successful one, and then the effects management hierarchy applies to all of that, or is it something else?
No, I think the whole proposal
from start to finish.
yeah.
Yes.
And in terms of length of time, the 20-year time frame
Yes.
as
Yes.
proposed.
So any question of residual effects, my understanding from what you've just said, would be at that latter point, after the final 5 years of rehabilitation of the final reach that's been diverted and returned, would be the point where the effects management hierarchy would be applied.
No, I don't think it's one point in time. As we discussed at the joint witness statement in preparing in the conferencing, I don't think it's one point in time. I don't think it's during the temporary divisions. I don't think it's at the year 20. I think it's the whole project, all the effects, the temporary and the permanent.
Okay, so
effects.
it's a rolling front. Is that what you're saying? I'm trying to understand. So as effects occur, that's when the effects manager at each, it just rolls through the whole thing, not at any point in time or at the end.
Yeah, all effects need to be considered against the effects management hierarchy. I don't think it's just the obvious effects, the more permanent ones. The temporary ones need to be considered against the effects management hierarchy as well, in my view.
Okay, thank you. I think that's my questioning. So I think thank you very much for that.
Thank you.
And I think you just have one deliverable that you've asked for. And we're just to confirm when that might be delivered by.
I'm part-time. I will do my best to get started tomorrow and after I drive home. And yeah, can I say Friday next week? I'll spend next week working on conditions and an assessment. You look like you prefer, how about Wednesday?
Well, I'm just afterwards, yeah. That sounds to be acceptable. So that's at close of business on Friday next week.
Okay.
Yes. Is that the 12th of December? Yes. Thank you. And you have a...
All right, I'll introduce Ms. Badenhop is going to talk to the science under the ground that she is really good at explaining in plain English for me and has been really helpful.
Okay, thank you. Well, thank you, Ms. Badenhop, is that right?
Badenhop.
Badenhop, thank you. Well, thank you.
I'm sure it probably was Badenhop at some point in time, but it's been destroyed through the years.
Well, thank you. Thank you for your summary statement. Will you take us perhaps through that?
Yes, I'll take you through that. So,
You're starting at paragraph 2.
Yes.
Yeah, yes.
yes, so I think it's important to recognise what the potential effects can be when we're looking at groundwater. So the activities that can affect groundwater quantity are dewatering of the open cut line, diversion of the stream, that should probably say Shepherd as well, installation and decommissioning of the bore via mixing and homogenising of the aquifer layers. So that's on the site specifically. Aquifer consolidation due to dewatering, which can occur both on the site and off the site. And the activities that... Thank you.
The question of water quality limits.
Yes.
I am somewhat troubled by the fact that the limits are uncertain right now, myself, and that they will sit in a plan rather than in a consent condition itself.
I think we actually suggested the limits should be in a condition of consent, is what Mr. Webber and I had discussed.
Yes.
At least for the discharge.
But we don't currently have those limits.
No, that's correct.
And that may take some to form those limits.
Yes.
So they probably will sit in a plan if we were of a mind to grant that with a plan as a condition. Well, I think you've answered my question about your preference for where such limits would sit in the consenting package.
Yes. And within the management plans, there would also be other trigger action response plans.
Yes.
For other components within the mine.
And with regard to the suggestion of monitoring sites above the mine, in the stream above the mine operations, and down below it at the whole operational site. Is your suggestion for the same suite of parameters as suggested currently in the AMD plan?
I think in terms of those continuous monitoring parameters, certainly. I think, forgive me if I end up stepping into ecologist realm here, but it is certainly within my expertise to discuss water quality. Temperature, pH, dissolved oxygen, turbidity, those things can all be monitored in stream quite simply, so they would be certainly aspects that I would consider to be important, with some grab sampling to understand more of the stream chemistry.
Or would it be to the same, I said the same parameters have been recommended to the same frequency, at the same time?
I don't think that would necessarily, if there was enough baseline information regarding the stream chemistry normally, I don't think that would necessarily be important for metals, for example, upstream. But for the other parameters, because there is, such as temperature, pH, those sorts of things that will change with diversions and that cover and turbidity, you would want to cover those.
So and would you expect that monitoring to continue on once the rehabilitation is completed?
To show that it's been effective, yes, I would suggest, if you want to determine if it's been effective.
I suppose I was thinking more in terms of any continuing effects from any discharge
yes,
from groundwater.
Sure.
Yes. Yes.
Yes, I think it would be reasonable to certainly include a review clause that determines whether or not that's necessary. Yes.
Okay, thank you. That's helpful. And in your summary, you just talk at 2.3 about potential for the drawdown to extend a significant distance.
Yes.
Can you give an estimate of what that distance might be? Have you given?
So Mr. Heller had assessed that there was potential for significant drawdown within groundwater bores to a distance of, I think it was 6.9 kilometres. Yes. That would be in his evidence.
Yes.
I apologise, these microphones usually are a little bit more than are usually this problematic. Okay. So, the Hokonui Runaka have stated that they have collaboratively drafted consent conditions with the applicant, and it was important for me to confirm that this is the case, and I think that has been transpired at this hearing over the course of the last 2 days. And it was also helpful to see at least an initial draft of the riparian planting plan. I have shared that draft with Mr. Moore, which we'll hear from later. It's also encouraging to see that there is an ongoing relationship agreement and that the Runanga are to be engaged throughout the mining and remediation process. The cultural impact assessment highlights the differences between Western science assessments of stream health and the cultural monitoring, and confirms that there has been significant degradation of Tonga species and cultural values. And in my view, the report stresses the need for robust monitoring. On the basis of the cultural impact assessment and the agreed framework of ongoing engagement, I am satisfied that there is now sufficient information that has been provided to conclude that Manawhenua values have been appropriately recognised and provided for. In relation to the transport matters, the applicant has provided further evidence on exact locations of access ways. I have passed this on to Mr. Murray, and he has provided an updated memo in terms of his final conclusions on those access points, mainly in relation to site distances. This has been appended to my supplementary evidence here, and Mr. Murray will be available to answer any questions that you have after lunch. Mr. Hasler confirms in that summary memo that he's satisfied with the proposed locations of the access ways, subject to the conditions that he has proposed. These conditions have been accepted by the applicant and are included in Ms. Colley's Appendix B set. Mr. Hazza has further confirmed that he's comfortable with the entranceway sign on the basis that the final design is provided to council for certification prior to its being established at the site. In terms of the road boundary planting, I've sort of left the question open in my Section 42A report, as it wasn't clear whether or not the applicant had landowner approval to establish this planting. It has been really helpful to hear from Mr. SB in terms of what the extent of effects are if that planting does not go ahead. I can confirm that the Gore District Council does not support the boundary planting being located in the road reserve. I accept the views from Mr. SB and also Mr. Moore in their joint witness statement that the planting would that the planting would reduce the effects overall. I think it is an important point that Mr. Espy made around the timing of the planting and the fact that actually its sort of effects would not be felt for the first 3 years, and at which point the mine has moved further into the site. So I take that on board, and whilst in my opinion the planting is desirable in terms of screening, I accept that actually in terms of our timeframes it might not achieve a great level of effect in the sort of those first few years, which is when it would be most needed. Also, I guess on that point, the views that we are considering is road line with sort of seasonal and then the actual rehabilitation. There were a few discrepancies about the sort of total time in that. Mainly the important thing is that in order to move through the pathways of the MPS for highly productive soil and rely on this sort of temporary nature, there does need to be a time frame. I am comfortable with it's 3 years as opposed to 2. The sort of overall time taken the land out of production seems to be sitting around that 5 years. So it's just around sort of, I guess, making sure that as soon as practicable after mining, there is rehabilitation and the land is then available again.
Thank you for that. And so in terms of your initial specification of 2 years, did that come from any particular concern, or you're not concerned of moving to 3? Is that what you're saying?
Yes, I'm not concerned with moving to 3. I think my 2 years came from the sort of having 3 years of mining and associated activities, and then the 2 years rehabilitation to create the 5. I think that's where I got my 2 years from.
Thank you very much for confirming that matter for us. Thank you. No further questions.
I don't have any further questions, actually, Ms. Hughes, but we're happy to hear from Mr. Moore. And you mentioned Mr. Hazard's not available right now, or?
I had said that he should be available from 1, so if it's I can probably go and find him though.
Well, I think it might be helpful.
Yes.
We're moving reasonably rapidly,
Okay.
and I think we may not take a lunch break, but go right through, and we should be completed by 1 or earlier.
Okay, I'll introduce Mr. Moore, and then if it's all right for me to duck out, I'll go and locate Mr. Hasler.
Yes. Unless someone else can do that on your behalf.
Yes.
So you might want to stay and hear this, of course. Or maybe, yes, Ms. Onke, Catherine, perhaps you can assist Ms. Hughes in just finding Mr. Hasler. Thank you. I'm not expecting a formal introduction, by the way, as a witness.
Okay, good.
But you're welcome to introduce Mr. Moore all the same.
Yes. Thank you. So this is Mr. Mike Moore. He's the landscape architect for Gore District Council. And I'll pass you over. Thank you.
Thank you.
Hello. I don't have anything or here to answer.
Oh, okay. So there's no summary of anything you want to refer to?
No, not particularly.
No?
I was just
Okay.
here to answer any queries you have.
Oh, okay.
Yeah.
All right. Thank you. Well, we received the joint witness statement, of course, which is fairly defining. We'll ask if there's any questions you have. Yes, there are. Thank you.
Thank you, Mr. Moore. Really just, I was interested in we have this joint witness statement. It appears that all the issues have been resolved between yourself and the applicant's landscape expert, but I am interested in hearing your process in terms of the additional written approvals that were obtained in relation to the visual and landscape impacts and how you see that currently, and also your opinion on the issue of the planting and the road reserve, the berm of the road.
Certainly.
Thank you.
The main one I picked up, and this is looking at the written approval side of it, was the property that hadn't been assessed by Vivian Espy on, I think it's Turnbulls Road. And I...
Some excuse. If you just introduce Mr. Hasler. Before we do, we don't actually currently have any specific questions, so I don't really want a wild goose chase to come here, but you might like to summary your understanding of the project and any concerns you may have. Ms. Skews, perhaps.
Okay. Thank you. This is Mr. Murray Hasler. He's Council's roading asset manager, and he has reviewed the application and provided a memo which was appended to my Section 48A report, which had sort of requested conditions and request for some further information, which we received through supplementary. Mr. Hasler has then provided a updated memo and can talk to that and answer any questions. Okay, so the microphone's on.
Thank you.
Thank you for the opportunity of commenting. So, in general, the proposal from the applicant was we viewed favourably, but there were some potential issues. The planting that I've just heard being talked about was one of those. The council has in the past had a roading bylaw which specifically excludes the planting within the road reserve, except in extraordinary situations, and generally those situations where the road reserve is much wider than normal, or it's on top of a bank on the side of the road that is not going to create any shading at any part of the day on the adjacent road. And also the other factors that come into it are things like the effect of those particular species that are going to be planted. Flax, for instance, is we do have a number of situations around the district where there is flax, and it creates a lot of problems for us in terms of drainage, maintenance. I heard willows being mentioned, and we have specific problems with willows blocking up drains and also, the side drains on roads, but they also have a significant tendency to form mats in culverts. The root systems, they go for the water, and they completely clog up culverts. We have where we've got wind-blown willows around the district close to culverts. We're often having to spend quite a bit of money to clean out those culverts. We haven't got any we're not opposed to planting, screen planting within the property boundaries, but we are not keen on plantings being planted within the road corridor. So the other issue that required a dispensation, I suppose, from our district plan was the sign size. Now, when I looked at that, we didn't have a design for the sign. We just had some basic parameters for the sign. However, in my opinion, it does that we can come to some agreement over the repair of that damage. I think that probably covers most of the aspects that we had any concern over.
And just on that latter point, you're satisfied that's landed appropriately for you for the routes that they're going to be used?
We haven't actually heard. We haven't been provided details of that. With the wind farms, or the wind farm, and also the proposed wind farm, the Southern Wind Farm, part of those projects was to provide a construction traffic management plan a certain period of time before the actual event, before the project started. And in my view, something similar to that would be appropriate once the applicant is able to provide the exact details of where things are coming from, how often they're coming, the size of those components in terms of weight, and the details of the vehicles that are going to be carrying in. Until those details are available, neither party is able to go much further than we have already.
That's okay, thank you. Do you have any questions? I have one question.
Thank you, Mr. Hasler, and thank you for coming ahead of schedule. Appreciate that. Okay. So in relation to the proposed accessway signage, you've communicated that you're comfortable with what is proposed, subject to a final certification by council. Yep. And I wanted to check if you had seen the condition put forward by Ms. Scusa for that, where she has inserted the words "for certification" within one of the consent conditions. Are you satisfied that that addresses the point that you were making?
Yes, I am satisfied with that, yep.
Thank you very much.
I have just one question about the boundary planting, and with regard to the signage, you talked about drivers being distracted, and I guess for road users, is sufficient boundary planting helpful or required for that purpose of road safety? Just distract people looking into the site to see what on earth's going on?
Yeah, it has its advantages and it has its disadvantages, because I suspect that even with boundary planting, whether it's preferably, as I say, inside the property boundary, there's likely to be gaps, and it may be more distracting if there's sudden gaps that people are suddenly distracted by. That's just my thoughts on it, but yeah, there's probably more than one school of thought on that. Because I don't think you're going to get complete screening with any plantings. I'm not.
No, thank you. That's fine.
An expert on that.
No. It was a slight distraction itself. But we have heard from the landscape experts that, yes, it may not be mature enough anyway to screen what's going on the site. I was just interested from a road safety perspective, but thank you. You've answered that. Thank you. So thank you, Mr. Hasner. Thanks for coming in.
Thank you.
Each section of that management plan will address to give some idea of the content without being the full content.
Will address, I think, and how it will be addressed as much as
yes.
practicables.
Yeah.
Including any further information requirements. Just on that, and perhaps with this timetable, I'm planning to send out a directive by the end of tomorrow, preferably detailing these matters.
That would be useful.
Yes, I think it just gives some guidance on what I have in my head.
Yes, perfect. And the chair helpfully indicated that you might have some example management plans, which may be the ones we've already found, but if you have any ideas that would
Sure.
be useful. I have also down on my list that I will provide my reply on that date and file that with the table of contents. In my mind, that will close off the outstanding information that the applicant thinks is needed. I should say I'll also respond if necessary to the conservation plan, because that's not something that we've addressed. I then had on my list, and stop me if I'm getting ahead of myself, but that as soon as possible thereafter, the commissioners will either issue a decision, or if that you consider that further information is required, or there needs to be a further round of comment, that can be the subject of a direction in the new year. So that's as far as I got, but there may be I'm in your hands as to whether there's other things, or that's not what you had in mind.
Well, that is, yes, it's broadly similar, actually, to be frank with you. I wasn't sure if you wanted to do your right to reply at that point or a later date. We can leave that just open right now. And obviously we will be having to look at all that information. We haven't ruled out further requests for further information, or indeed reconvening if we need further discussion on some matters, which I imagine would be online. It wouldn't be a lengthy exercise. And I also noted Ms. Smith offered their legal representative. We may have some questions as well that we would put in writing and circulate those, but to him as well. And again, that will depend on what we get back, probably from these various exercises. So if you want to revise your right of reply, comment, because this is probably all going to come after all of this is in by the 19th.
Yes.
So it's going to be early next year, really.
Yes.
Realistically.